Good morning. Gary DeWaal here, and this is Bridging the Week for June 30th to July 4th, and today is July 7th, 2014. It was a short work week in the United States because of the Independence Day holiday. However, it seemed like a very long work week because of the U.S. loss in the World Cup. Despite the shortness of the work week and the disappointment over the U.S. team's loss, there were some significant developments impacting the financial services industry, including a long-awaited fine against BNP Paribas for evading U.S. economic sanctions, as well as an important court decision extending the attorney-client privilege in connection with investigations ordered by in-house counsel. Let's get this game going right away, however. So, here we go. BNP Paribas agreed last week to settle charges related to its processing of U.S. dollar transactions on behalf of Sudanese, Iranian, and Cuban entities that are subject to U.S. economic sanctions. As part of its settlement with the United States Department of Justice and the Manhattan District Attorney's Office, BNP will pay a penalty of almost $9 billion U.S. dollars. According to a statement of facts agreed by the Justice Department and BNP, the bank's wrongful conduct occurred from 2004 to 2012. During this time, the bank helped process almost $9 billion U.S. dollars through the U.S. financial system on behalf of the prohibited entities. The bank endeavored to hide its conduct from regulators by concealing the names of the prohibited entities and its own role, says the Justice Department and BNP. BNP was charged by the Justice Department with violating the economic sanctions, while the bank was charged by the Manhattan District Attorney with falsifying business records. Michel Barnier, the European Commissioner for Internal Market and Services, said in a statement on June 27 that he is close to recommending to the European Commission that 5 clearinghouses outside the European Union should receive equivalence decisions. Such a decision would allow these clearinghouses to clear EU derivative trades. The relevant jurisdictions are Australia, Hong Kong, India, Japan, and Singapore. Who's missing? The U.S. was not mentioned, although Mr. Barnier indicated that he was quote-unquote confident that ultimately the U.S. would be included. However, the decision process seems to be as much political as substantive. According to Mr. Barnier, our technical talks with the CFTC are progressing well. Quote, if the CFTC also gives equivalence to third country CCPs, deferring to strong and rigorous rules in jurisdictions such as the EU, we will be able to adopt equivalence decisions very soon. End of quote. I guess the U.S. is about to play in a different ballgame. The U.S. Court of Appeals for the District of Columbia Circuit broadly applied the attorney-client privilege to internal corporate investigations conducted at the request of company counsel, even where the investigation was not conducted solely for purposes of rendering legal advice, but for other purposes too. In the case, In re Kellogg Brown and Root, the company's law department had commissioned an internal inquiry following an employee complaint. As a defense contractor, Kellogg Brown was obligated to investigate allegations of potential wrongdoing by applicable U.S. Department of Defense regulations. The lower court had said that the attorney-client privilege did not apply to the investigation because it was not conducted, quote-unquote, but for the purpose of giving legal advice. It was undertaken also to apply with the company's regulatory obligation. The Court of Appeals rejected this approach and held for a broader application of the privilege. And finally, the CME Group brought a disciplinary action against an individual member solely for offering to sell futures contracts that, if successfully executed, would have caused the trader to hold positions in excess of applicable speculative position limits. The trades were not executed, however. On July 24, 2013, Daniel Zagarin placed an offer to sell 12,000 contracts of August 13 soybean meal futures at a time when he was long 610 contracts. Had his offer been consummated, he would have exceeded the relevant position limit, namely 6,500 contracts, by 4,890 contracts. Mr. Zagarin agreed to settle this matter by payment of a fine of $100,000 US dollars and to be denied access to CME Group trading for 30 days. Well, that's it for this week's Bridging the Week. which has had a bit less news than usual. That being said, as always, there's more information in each article and more videos on the article version of Bridging the Week on the Gary DeWaal & Associates website. Check them out. In any case, until next week, this is Gary DeWaal. Have a great week, and ciao